May it please the court?
Sure.
Attorney Douglas Rand Peacock, appearing for Market Kappa Investments LLC as trustee. Basis of our appeal is questioning the evidence that the court relied upon in both admitting the testimony of the Plaintiff Bank's witness and also the evidence to establish that there was actually endorsed copy of the note in the plaintiff's possession prior to the filing of the complaint.
Why does your client have standing to raise either one of these issues?
Well, they were the property owner.
You bought a deed at a county court foreclosure sale? Is that what you did?
Yes, Your Honor.
And what was the status of this foreclosure when you bought at that sale?
I believe that the foreclosure was already in place, Your Honor. It started, but
it was filed.
It was filed.
Had the owner defended?
The owner, I'm not sure if the owner had defended or not. To be frank with the court, I know that the HOA had defended in this case and had put forward defenses challenging standing from the beginning of the case. So from a standpoint, we took our interest through the HOA's foreclosure.
Because you're not liable on the note?
No, Your Honor.
Mortgage hasn't been assigned to you?
That's correct.
And you bought with eyes wide open knowing that you were buying a piece of property subject to a first mortgage that was already in foreclosure and that the owner of the property had defaulted?
And assuming the bank had produced admissible evidence at trial, we would have lose the property. Yes, we took it subject to those defendants, knowing that there was a potential issue. However, that does not, I think, in any way preclude us, and I would point to the Clay County Land Trust versus JPMorgan Chase case up in 1st District.
Did the trial court ever enter an order allowing you to intervene?
We had filed a motion. The order had not been heard.
So what are you in this case?
We are the property owner who has
You're the appellant here, but you were never a party below.
And I would still point to the Clay County case, which would, even where we moved to intervene, which didn't even happen in that case, the court allowed us to be an appellant and to challenge
I haven't seen the judgment on appeal here. Is Market Tampa Investments named as a defendant in the judgment on appeal?
No, I do not believe it is.
Well,
it is in so much as
if there was never an order allowing you to intervene and your client's name is not on the judgment, how are we here?
Well, Your Honor, all I can point to is that the plaintiff may have made an objection to us being there at trial. Only brought the issue up on appeal. The court was very aware of our position as the property owner and let us proceed with our defense and questioning of the evidence.
We're getting mixed cases coming here. We're seeing a lot of these right now, and sometimes the motion to intervene is denied, and sometimes it's granted. And this was the first one I've seen where nothing happened at all, and so I'm not quite sure that you're a party, frankly.
Well, Your Honor, again, I'm pointing to you brought this issue up, and I'm pointing to a subsequent case that came out, which is in the first DCA, where the court looked past that and said that a party who has a fundamental property interest, regardless of how they came into it, has a right to come in and at least challenge at a base level the plaintiff's ability to foreclose on the property, or at least test the evidence, which is what we did here. We were not raising fundamental issues, or in this case was not decided on the issue of whether proper assignments were given to the note the signers of the original note. We're not challenging on those issues. We're challenging on simply the very basic issue, which the court would have had to have established regardless of our presence in the case.
Why does the standing issue you're raising make any difference to your client?
Well, Your Honor.
I mean, because apparently there is an original note and mortgage, and it's in the record and all of that, right?
But there is no evidence that it was actually endorsed. This was a lost note count originally, where a copy of the note was not even attached to the complaint, and that's evidenced by the record, which only has enough pages for the complaint and the mortgage itself, and I believe an HOA writer. There's no note there was no evidence that the plaintiff had any indication that they even had the note prior to the filing. Certainly, there was admission of a screen print showing that they supposedly had sent the original note to the prior plaintiff's counsel. However, the witness openly admitted that she could not say when the endorsements were placed on there, and all of her knowledge or her testimony was based both on her belief and assumption, that is, that it was placed prior to them sending it over, and also on other records which were not admitted. That is this document system, imaging system. So we don't even know if there were other copies imaged on there. We just have her hearsay testimony about those documents. So we think that there still is a basic standing issue, particularly in light of the recent 4th DCA rulings, which have reestablished Florida law that the bank has to show through admissible evidence that they have a right to foreclose on the property. We came into this case, yes, there was a lis pendens. However, the lis pendens statute, if you read it, only applies to unreported interest, such as I wanted a poker fight or poker match 2 weeks before, I haven't got it to the court's house, now you're foreclosing, I got so many days to come in and put my interest in. We came in subject to a lawful county court foreclosure action by the HOA, bought the property, came in, rehabilitated it, and then showed up at court only trying to challenge the evidence or at least test the evidence, and we found there were gaps. So and Florida courts have allowed people or homeowners like ourselves to come in and challenge this because there is a fundamental property right interest in Florida. Once you own property legally, you have a right to at least challenge or at least defend it or whatever rights you might have had. I'm not going so far as to say that the bank has to refile or bring us in as a formal party once we've bought this. I think the lis pendens statute protects them from that, but I don't think it protects them from us as property owners coming in and at least asserting our basic rights, saying, do you have the right to take it from whomever under this assignment? Have you done everything, or at least have admissible evidence that you're the right party? And given this is a case where it's not the originator of the loan, in this case it wasn't even testimony at trial, the actual party who filed the case. It was a subsequent servicer claiming to have gotten it through it and showing up with a signed power of attorney referencing an unsigned purchase and assumption agreement. So even the witness's authority to testify was somewhat questionable because, yes, she has the power to enforce an agreement that was never executed, or at least we don't know it was executed because the best evidence was not presented to the court. All of these things, even had we not been present, the judge should have taken note of, excluded, and then the bank could have come back when they had their ducks in a row. In our case, we pointed out to the court that ducks were not in a row, and the court overruled. Didn't follow the evidence code, and went forward.
Was there anyone at the hearing other than your client? But the homeowners association by this point in time foreclosed their own.
Well, that was part of when we came in and bought the property, we made the homeowners association whole.
Right.
We paid off.
So they no longer cared.
Yes, their interest had subsided because we had come in to save the property and community by at least becoming a functioning member of it, making them whole and rehabilitating the property, getting people back in there, not just letting it stay vacant for vandals. So yes, the HOA bowed out prior to trial, and it was only us.
Okay.
And the only other point I issued out, which I guess we had it on our brief, was that there is a Feltis issue in this case, in so much as they had a 2-count complaint and never formally moved to amend it. And so even though they have a lost notice of dropping count 2, that doesn't necessarily amend the original complaint or the claims in which they're going forward on. So there's still an issue of their prima facie case should have been established for this lost note count, or they should have been forced to amend their complaint to put forward a clear state of the claims. That I'll reserve for.
Okay.
Good morning, Your Honors. May it please the Court, my name is Henry Bowles. I'm here with Ackerman LLP here today on behalf of the appellee and plaintiff below Nation Star.
Excuse me.
It's clear that the Court has a grasp on our initial position, which is that, there is the appellant here had injected itself into a completely simple mortgage foreclosure action without any basis under the law. As set forth in our answer brief, they were barred from intervening in the first place. They also failed to secure an order at any time or, to hold a hearing where we could challenge their intervention. And then to the extent that they were...
Did they attend the final hearing?
Excuse me, Your Honor?
Did they attend the final hearing?
Certainly, Your Honor. They were in attendance at trial,
And
yes.
did North Star object to them being there?
Nation Star did not specifically object to them being there, but if you look at the record, Your Honor, at the beginning of the trial, the first things that were handed up to the judge, and in accordance with our request for judicial notice, were the assignment of mortgage, the lease pendants on the property, the foreclosure docket from the county court, homeowners association, foreclosure, and the power of attorney. So it was clear that, you know, everything that the judge needed to know that there was no real interest here on the other side was presented to it. But yes, the trial court, you know, the trial did go forward, and to the extent they were, you know, the last point I didn't quite get to the extent they were properly, or to the extent they were allowed to intervene, as an intervener, they are, you know, they're barred from attacking the pleadings, as an intervener has to take the pleadings as they find them in a case such as this. But all of this is ultimately irrelevant. This foreclosure action was completely proper. All of the evidence supports all of the elements of a foreclosure claim. The default, failure to cure, the execution of the loan documents, and the evidence is extensive on the point of Nation Star standing to foreclose. Both Nation Star standing to foreclose and take over the case, as well as Flagstar, the initial foreclosing plaintiff's ability to foreclose at the outset of the case in 2009, 3 years before Market Tampa took a flyer and, you know, tried to purchase this property and inject itself into it and, you know, try to gum things up. The evidence on standing is clear, and it centers on a screenshot, a business record that was properly admitted into evidence showing that the original note was sent from Flagstar to their foreclosure counsel at the time, Ben Ezra Katz, on the actual date of September 10th, 2009, which is 6 days prior to this action being filed. That was clearly in the record. They didn't send that to them without having it. So that, you know, that is, you know, clearly detailed possession at the time, possession of the original note at the time the complaint was filed, which is sufficient for standing. The question raised at trial was whether there was proof that the endorsements were on there. Kristen Trumpus was the Nation Star witness who testified, and she testified that yes, she knew and could testify clearly that those endorsements were on there. At the time of the trial, she hadn't even seen the original note. It had been sent by Flagstar, the initiating plaintiff, to its foreclosure counsel, who had filed it in the court shortly after, in January, I believe, of the next year. And she testified that in Nation Star's records, which were boarded over from Flagstar, the initiating plaintiff, those records had a copy of the note in them that was imaged by Flagstar before they sent the original note to their counsel that contained the endorsements. And if you compare the two that are in the record, the copy that was testified to, which is in the record at page 313, and the actual original note that was filed with the court shortly after the complaint was filed at page 42, those match up entirely. So the witness knew that the note was endorsed in blank, properly endorsed with the correct chain from start to finish at the outset. To briefly address this argument that the authority to testify, the Nation Star's authority to, and Kristen Trumpus' authority to be present in court, that's an issue that wasn't raised below, is not proper for this court to consider. But nevertheless, there was an enormous amount of evidence reflecting that, when all that really was relevant was possession at the time. Evidence was entered about the assignment of mortgage from the originating lender to Flagstar, a notice of transfer of all the servicing rights from 2006, a welcome letter sent to the borrowers advising them that Nation Star was becoming the servicer of this loan back in October of 2009, power of attorney from Flagstar to Nation Star, giving them these powers, which also included this asset purchase agreement, showing that Nation Star took a pool of loans from Flagstar. And a point I have to make here is, as we know, they did attend trial, they did appear, and there was no evidence presented that contradicts any of the evidence that was presented to support Nation Star's standing in foreclosure case. Nothing on the other side. So our position, Your Honor, is very simple. The judgment is well supported by the evidence. All the evidentiary rulings that were made in getting there were well within the court's discretion and made properly. And the final judgment of foreclosure should be affirmed. So unless the panel has any questions, I've laid out our position.
Thank you.
Thank you, Your Honors.
Just a quick
I'm
follow-up.
just still trying to figure out a little bit on this order. Who was the lawyer that appeared for your client at the final hearing?
Uta Grove, Your Honor.
I'm sorry, who?
Uta Grove.
Because I don't see any copy of, a conformed copy being sent.
I believe we got the copy from the clerk's office, Your Honor. As I said, I don't believe we were named on the.
You're not named on it, and it wasn't sent.
Correct, Your Honor.
All right. I'm just still struggling just legally with how you're a party below to bring this appeal. You have to be a party in the lower court proceeding.
Well, Your Honor, I've said the Clay County case, and I will submit a subsequent.
So, in the Clay County case, someone was not a party and was not had no order of intervention, and they were still allowed to appeal?
Yes, Your Honor. Specifically, the court said, as the current owner of the property, appellant has standing to challenge, in that case, claim holder's affidavit as the amounts of the debt owed because it related to appellant's right of redemption.
And that was in the case where the trial court didn't allow intervention?
That was in a summary judgment, yes.
Okay, what's the site on that case again?
It is 1D14-1838, and the November 20th, 2014.
So it's a first district case from November 20th?
Yes, Your Honor.
Okay, thanks.
And just as rebuttal, the assignments that the plaintiff refers to all posted the complaint. We're conceding that there is some evidence, monochrome, that they had the physical note or something claimed to be the physical note prior to the filing. However, there is absolutely no evidence that there were any endorsements on it. And that's the key issue. The Joseph versus BAC case.
There weren't endorsements at the time it was filed, but there were by the time of the final hearing, or what?
There was no copy of it at the time it was filed. The only first time we see anything with a note is when they filed the notice of filing the original note subsequent to the filing of the case. However, at trial, the witness was questioned and admitted that her entire knowledge was based on an assumption and belief that the endorsements were on there prior to, and again, based on a document system, the only evidence of which we saw was the produced copy of the note. So,
but I'm still struggling with why, if there is an original note and mortgage in this record, and I'm assuming that there is, that as the purchaser at the county court foreclosure proceeding, at some subsequent time, you have any legal right to fight about whether there was standing at the beginning. You're not a party to the note or the mortgage.
Well, Your Honor, we are a property owner. And as I have said, Florida courts have allowed property owners not only to have a right to intervene,
but you took it subject to a pending foreclosure case.
Yes, on pleadings that led to a lost note count.
And your property is merely collateral in their lawsuit.
That is correct.
And so why does the fact that you chose to do this when you did it give you right to fight about standing at the beginning of someone else's lawsuit when they are not fighting about it?
If they have a faulty claim of collateral, they have no right to collect it. And if we obtain it through otherwise lawful means.
Why does the standing at the beginning of a foreclosure case make it faulty collateral?
If they didn't, Your Honor, if they did not own the property, own the note, with it endorsed in blank, which is their current theory at trial.
Well, if they own it at the date of the final hearing, and it is in default, and you're not paying the note, and no one else is paying the note, how does your client, even if there's an order of intervention, your intervention is subsidiary to the party's lawsuit?
Well,
and the owner of the person obligated to pay on the note, and the party who owned the house when everything commenced, is not choosing to disagree about any of this.
Your Honor, even for the plaintiff to succeed in a default situation, they still have to prove at the time of filing, through admissible evidence, they have to establish through admissible evidence at the time of filing that they had the rights to enforce the collateral
agreement. At the time of filing?
At the time of filing.
Isn't that an affirmative defense of standing? Isn't that what the case law says it is? It's waivable?
However, it was not waived. We still came in through
the owner defaulted. Of course it's waived.
The HOA did not waive that. It raised that as an issue.
And then the HOA went ahead and foreclosed and got itself fully satisfied. It's got no standing in this case at all. Does it?
Your Honor, I still don't, I don't think it's first of all, I'm not sure that it can be waived, in the sense that if they didn't have standing, then some other party had the rights to do so. If this were just simply a car or some other piece of chattel, we could say, okay, maybe it's okay if the wrong party gets it, they can get recompense through other means. Real property is different. It requires the mortgage, it requires all the constitutional protections of owning property in the state of Florida, including having a valid lien to go forward with. In this particular case, the issue of standing was raised before the court prior to my clients coming in, so it was an issue the plaintiff had to overcome. At the very least, we got our ownership through the HOA, not through the homeowners, not as if we purchased it from the homeowner and then OG got a bum deal.
Right, you got a thinner title than a, you didn't get title from the owner, you got it through a foreclosure sale with another foreclosure case pending.
Was there any transfer of rights or assigned rights from the homeowners association to your client? If you're trying to travel on their pleadings? Because it got reduced to a final judgment in the foreclosure count, but let's assume they file in this case too?
I would say we had whatever rights the court could give us, as would be standard with any court sale. That is, there wasn't an assignment of rights so much as the action we purchased it through. But that would be the same as when a bank gets a property from an HOA sale and then promptly resells it.
When the HOA does this, and I don't know the answer to this, does the homeowner still have, from a homestead standpoint, a redemption period on these things?
I believe they do, Your Honor.
How long is it?
I think the standard, is the standard rate for any foreclosure action.
What was is the foreclosure judgment and the information about the county court in our record? And you're referring to the county court? Right. I'm curious as to what the amount of the foreclosure judgment was in county court, and I'm a little bit curious as to what was paid at the foreclosure sale.
I don't believe it is. I think there's only a certificate of title.
Yeah.
From our motion to intervene, which was not.
Because I'm assuming this was a fairly small amount. Since it was in county court, it had to be a small foreclosure judgment, and I'm betting your client bought this property for $100, but.
I think it's a bit more than that, but I grant what Your Honor's going for.
Yeah. All right, I'm sorry, I'm distracting you. If you got more to say about the argument, go ahead.
No, Your Honor, that's basically, we're still holding to the position that there is not a plethora of evidence to establish their actual standing at the time, and that even, again, a court has a gatekeeper function of making sure that before property changes over, they're not just protecting against the homeowner's interest, but also other potential claimants' interest as to was there sufficient evidence to go forward with a foreclosure. We feel there was not. Thank you.
All right, that concludes our docket, and court's adjourned.